Hi friends, this is Advocate Suman Kumar Singh. Welcome all of you at my YouTube channel of Yashasvi Law Classes. Today we are going to start introduction class of the Code of Criminal Procedure 1973, which is very important for all judicial and APO services pre-examination. Before Mughals, there is no uniform law of criminal procedure for whole India. In the medieval India, subsequent to the law set by Muslims, the Muhammadan criminal law came into prevalence. During East India Company rule in 1973, Regulating Act was passed, which is provided establishment of Supreme Court in Calcutta, and British procedural law was applying while deciding the case. Eventually, later on, other court at Bombay and Madras, under supervision of that Supreme Court, was also established. Then after rebellion of 1857, Crown took over the administration of India. For the first time, the Criminal Procedure Code 1861 was passed in British Parliament. The Cr.P.C was created for the first time in 1882 and then amended in 1898 according to 41st Law Commission report in 1973. The current Cr.P.C came into force. Before moving ahead, it is important to see the bare act of this code, that in very first line it is mentioned that an act to consolidate and amend the law relating to criminal procedure, be it enacted by the Parliament in 24th year of the Republic of India. So it is clear from that line that this code was enacted after 24th year of independence. And some important bodies to function under this code are Supreme Court, all high courts, district and session judge, judicial magistrate, executive magistrate, police, public prosecutor, defense counsel, correctional service personnel, etc. Next. Section 1. Short title, extent and commencement. Before 5th August 2019, when Government of India revoked the special status or limited autonomy granted under Section 370 of Indian Constitution to Jammu and Kashmir, this act was not enforceable in Jammu and Kashmir, but after revocation of Article 370 from there, this act is enforceable to whole of India. The act may be called as Criminal Procedure Code 1973 and it extends to whole of India. Provides still there is some terms and condition made available that the provision of this code other than those relating to chapter 8, 10 and 11 thereof shall not apply. That means security for keeping peace and for good behavior. Chapter 10, maintenance of public order and tranquility, and chapter 11, preventive action of the police. So this code is applied only on chapter 8, 10 and 11 to the state of Nagaland to its tribal area, but concerned state government may by notification apply such provision or any of them to whole or part of the state of Nagaland or such tribal area, as the case may be, with such supplemental, incidental and consequential modification as may be specified in notification. It shall come into force on the first day of April 1974. Next, Section 2. Definitions. My dear friend, Section 2 of Cr.P.C is very important as the definitions are mentioned in it and the questions comes directly from these sections. So before proceeding, we need to understand the meaning of the sentence that in this code unless the context otherwise required. Which definition exactly given in this section are when applicable, when this definition is not applicable. Let's see. Let's understand what does this word means. First, break all the terms. That means first is unless, which means except. Second, context. That means particular circumstances. Third is otherwise. That means apart from else. Fourth is required. That means need. So we can see that except particular circumstances, apart from that need. So we can say that if there is any circumstances for the particular case that requires a different meaning for a definition, or the definition may have different meaning as per the situation or as per the case, it means different meaning of definition shall prevail over the general definition in special circumstances. In other words, we can say that definition provided thereunder would be an inclusive and not an exclusive definition. Okay, the definitions in the CRPC is mentioned in alphabetic manner. That means word B is followed by A, C is followed by B, and so on. And there is one most important thing, that there is the term is defined in this definition section, in the section 2, except the word A, D, E, F, G, K, Q, R, T, U, X, Y, Z. If the word is started from these words, that means there is no definition started from these words. If question comes from these words, you can eliminate that question, that there is no definition available in section 2 which started from A, D, E, F, G, K, Q, R, T, U, X, Y, Z. Apart from this, all the alphabet are available in the definition. So let's start with the definitions. A, bailable offense. That means in alphabetic order, B comes after A. So there is no definition available from word A. There is no definition available in alphabetic A. So bailable offense which start from B. B, charge which start from C. And again C, cognizable offense. Complaint. These three words start from C. So I mentioned all these three are in same color. Charges, cognizable offense, complaint. Police person are applying charges. Second, that charges may be cognizable. And third, this person informed the complainant that your complaint is cognizable. I am just mentioning this thing to memorize that term only. That's it. There is nothing like that. Okay. Next, High Court. F, India. G, inquiry. H, investigation. I, judicial proceeding. So there you can set a story behind that. Your case is in High Court, which is situated in India, where the inquiry began. In inquiry, there is a need of investigation. After the investigation, your case is in judicial proceeding. So we can set this story, and according to when question comes, then we can just remember that story and eliminate the wrong answer or correct answer. But I suggest don't set any story, because for that we need to remember that story as well as sections also. If we forget the story, our section will totally gone from our mind. Next, local jurisdiction. K, metropolitan area. I, non-cognizable offense. C, cognizable offense is mentioned in C, and L, non-cognizable offenses. Both are very far from each other, so we can club together C, L. That one thing, that C for casual, L for leave. So casual leave, that means cognizable offense. L for non-cognizable offense. C, leave, non-cognizable offense. Okay, so just remember casual leave, that means cognizable offense. L, non-cognizable offense. M, notification. O, officer in charge of police station. P, place, any place. Next, Q, pleader. R, police report. S, police station. S, police station. T prescribed, U public prosecutor. So there is a 6 word which is started from P comes in a row, that is place, leader, police report, police station, prescribed, public prosecutor. We can remember this word in a sequence from a story that there is a place in India where leader is residing, where he gets a police report from police station in a prescribed manner, which is scrutinized by public prosecutor. So PQRSTU. P started from P place and U till U. Next V subdivision. W summon case. WA victim. The word victim inserted in 2009. X warrant case. Next, bailable offense. Now let's see what the term is being defined in this section. First, bailable offense means an offense which is shown as bailable in first schedule or which is made bailable by any other law for the time being in force, and non-bailable offense means any other offense. Before proceeding to other subsection, it is necessary to see some fact of the Cr.P.C is that there is a 37 chapters along with 484 sections and 2 schedules. In first schedule, the offense is being classified and whether offense are bailable, non-bailable, cognizable or non-cognizable, and where the case will tribal. I will also make a video on that schedule, and I will try to make some trick which make easy to memorize that schedule also, because questions are directly comes from that schedule also. Charge. Section 2 subsection B. Charge. Include all head of charge when the charge contains more head than one. It is a little confusing. Let's simplify this definition. Charge. Include one head of charge. That means suppose an accused does any crime, he will charge for that. Along with, if there is more than one allegation on him, that means he will charge for that offense also. Charge include one head of charge, that means for one crime, or when the charge contains more than one head, that means more than one crime. Okay. Next, there is also a framing of charges mentioned in section 228. If after such consideration of hearing, as aforesaid, the judge is of opinion that there is a ground for presuming that accused has committed an offense. That means section 228 mentioned in chapter 18, trial before the court of session, in which framing of charges is mentioned in section 228. I just mentioned this section to memorize. It will easy to memorize that charge, where charge is mentioned in the Cr.P.C more than the definition. So that's why I mentioned this section here. Next, cognizable offense. Section 2 subsection C. Cognizable offense means an offense for which, and cognizable case means a case in which a police officer may, in accordance with the first schedule or under any other law for the time being in force, arrest without warrant. Cognizable offense means if accused committed any offense which is heinous crime. In that case, it is mentioned in a first schedule where police officer does not require warrant from magistrate and he can arrest that person without warrant. Such case will be considered as cognizable offense. And non-cognizables, what I told you earlier, that non-cognizable offense which is mentioned in L, CL, casual leave. I am just mentioning this because refreshing the memory. Okay, next. Complaint means any allegation made orally or in writing to a magistrate with a view to his taking action under this code that some person, whether known or unknown, has committed an offense but does not include a police report. That means a person or complainant made an allegation on any person orally or in writing for taking action for that offense, whether person is known or unknown has committed any offense in that case, but it does not include a police report. We will see police report further in the definition. Explanation. A report made by police officer in a case discloses after investigation the commission of non-cognizable offence shall be deemed to be a complaint, and police officer by whom such report is made shall be deemed to be complainant. So here police officer after investigation came to know that offence committed by accused is a non-cognizable offence, and after that report is prepared by police officer, such report deemed to be complaint, and that police officer who prepared that report is deemed to be a complainant. Next, E. High Court means in relation to any state, the High Court for the state. In every state there is a High Court. Second, in relation to Union Territory to which the jurisdiction of High Court for a state has been extended by law, that High Court. That means there is a High Court whose jurisdiction is more than one territory. For example, there is a High Court in Chandigarh. This High Court is for Haryana, Chandigarh and Punjab also. So one High Court has jurisdiction for more than one state or union territory. In relation to any union territory, the highest court of criminal appeal for the territory than the Supreme Court of India. In a state or union territory, the High Court is the highest appellate authority. Like after that, there is a Supreme Court of India. Next, India, our India, means territory which this code extends. That means all the places which comes under the territory of India. Next, G. Inquiry. Every inquiry other than trial conducted under this code by a magistrate or court. That means all the inquiry which is conducted by magistrate, not other than magistrate. On the direction of magistrate, maybe there is some person who can conduct it, but according to the definition, magistrate must be there. And other than trial means trial is a proceeding where any accused being charged and trial under any section available in penal code and other law which is for the time being enforced. Next, investigation include all the proceeding under this code for the collection of evidence conducted by the police officer or by any person who is authorized by magistrate in this behalf. So investigation means the collection of evidence. One question has been asked from this subsection in UP APO examination, that object of investigation is to punish the accused, to acquit the accused, to collect the evidence, to convict the accused. So we must go through the definition part of Cr.P.C. So here investigation means the collection of evidence conducted by police officer or by any other person other than magistrate who is authorized by magistrate in this behalf. Next, I. Judicial proceeding. Proceeding in the course of which evidence is or may be legally taken on oath. So it is clear from this definition that in judicial proceeding where evidence is or may be legally taken on oath is only called judicial proceeding. Next, local jurisdiction. In relation to a court or magistrate means the local area within which a court or magistrate may exercise all or any of its or his power under this code, and such local area may comprise the whole of the state or any part of the state as the state government may by notification specify. Local jurisdiction area where any magistrate, where a court or magistrate exercising his all powers under this code or any area which notified by state government shall be called local jurisdiction. Next, metropolitan area means area declared or deemed to be declared under section 8 to be a metropolitan area. Next, non-cognizable offence means offence for which a non-cognizable case means a case in which police officer has no authority to arrest without warrant. Now we can again refresh our memory and come to cognizable offence. Where it is mentioned in subsection C, CL, casual leave. non-cognizable offense means such offense in which police officer cannot arrest offender without warrant. Next, M. Notification means notification public in official gazette. Next, offense means any act or omission made punishable by any law for the time being in force and include any act in respect of which complaint may be under section 20 of the Cattle Trespass Act 1871. That means any offense or omission which is punishable by any law for the time being in force. That means any penal law, Indian Penal Code, or Domestic Violence Act, or like such act which is for time being in force, under which if any accused committed any crime and he will punishable accordingly. That is called offense. Officer in charge of police station include when the officer in charge of police station is absent from the station house, unable from illness or other cause to perform his duty, the police officer present at the station house who is next in rank to such officer and is above the rank of constable, or when the state government so directs any other police officer so present. In simple word, any police officer who is authorized by government above the rank of constable is officer in charge of police station performing his duty at police station. Next, place include house, building, tent, vessel, vehicle and vessel. Q. Pleader when used with the reference to any proceeding in any court means a person authorized by or under any law for the time being in force to practice in such court and includes any other person appointed with the permission of the court to act in such proceeding. His pleader means who is authorized by law to present before the court and argue over there with the permission of the court or any act in force for the time being is called pleader. Next, police report means a report forwarded by the police officer to magistrate under subsection 2 of 173. Means a report prepared by police officer and submitted to magistrate is called police report. In section 173 it is mentioned that report of police officer on completion of investigation. That means any police officer who is authorized to investigate for any offense, after completion of investigation the police officer submitted the report to magistrate is called police report. Next, police station means any post or place declared generally or especially by state government to be a police station and includes any local area specified by the state government in this behalf. That means any state government declare that any place or any post, that is police station, in his behalf. That means state government generally or especially declare any place or post that as police station is called police station. Next, prescribed means prescribed by rule made by this code. Anything mentioned in this code is called prescribed by this code. Public prosecutor means any person appointed under section 24 and includes any person acting under the direction of public prosecutor. That means public prosecutor means any person appointed under section 24 and includes those person also who is working under direction of public prosecutor is called public prosecutor. Next, subdivision means a subdivision of district. For the administration purpose, the state government bifurcate the district in subdivision. So that subdivision is called subdivision. Next, summon case means a case relating to the offense and not being in a warrant case. Now further, in next subsection we will study the warrant case. There we can understand the summon case also. Next, victim means a person who has suffered any loss or injury caused by a reason of the act or omission for which accused person has been charged. And expression victim include his or her guardian or legal. This section has been added in 2009. And victim and defined as a person who has suffered any loss or injury caused by accused due to his act or omission is called victim. And victim is also include his guardian, legal guardian or heirs. Next, X, warrant case, means a case relating to offence punishable with a death, imprisonment for life, or imprisonment for term exceeding 2 years. That means those cases in which punishment is death, imprisonment for life, or term exceeding more, the imprisonment term exceeding 2 years is considered as warrant case. That means summon case is that in which imprisonment is less than 2 years is considered as summon case. Last subsection of this section. Word and expression used herein and not defined but defined in the Indian Penal Code have meaning respectively assigned to them in that code. So this section is saying if there is any word or expression which is not defined in the CRPC and which is defined in IPC have been same meaning in simple. Here we have completed the intro part of CRPC. I would like your suggestion that how much this video helped you to understand the intro part of CRPC. Thank you very much.